Right. Everyone has a sheet. Again, you can do those now. You can do them after. Put the extra stuff over there. But it's just, take a couple notes on the ideas to give your opinion about how this case has gone at the end. First of all, I want to thank all of our distinguished panelists who take time out of their professional day to come and see you and talk to you about the law, about constitutional rights, and to go through this exercise, which will be a motion to suppress hearing, such as you would see at a courthouse on a regular basis. So we have Attorney Robert Hoffman, we have Judge Robert Rufo, we have Assistant District Attorney Ned Lynch, and we have Sergeant Jacek of the Harwich Police Department. With that, I will turn it over to Judge Rufo to introduce and start the exercise.
Good morning. You folks still called Harwich High? I don't think so, right?
It is. It's still Harwich High for another year. In the Monomoy Public Schools, but still Harwich High.
I live in Harwich, so my name's Robert Rufo. I live in Harwich. I've lived here for quite a long time, since I was in 1984. So I have the privilege of sitting as a judge now here in Barnstable County. I sit at the Barnstable Superior Court up on Route 6A in Barnstable Village, and it's not too far from home. And it's a very busy place, and we see a lot of cases that come before us on the criminal side of the court now from our entire county. The county of Barnstable comprises 15 townships, of which Harwich, of course, is one. And then we have the district courts. Orleans District Court, it has jurisdiction over Harwich cases, and in Barnstable there's a district court, and in Falmouth there's a district court. But I sit on the Superior Court, which is a little bit different venue. And regularly, I sit on the criminal side of the court, where we have to hear pretrial motions where a case has already begun, that the person is before the court facing criminal charges, and there is a thought process that it is engaged in by the defense attorney that just possibly the police, who are doing their job in a very tough environment, they're out in the street, they have to make split-second judgment calls about whether or not they have sufficient facts necessary to effectuate a lawful seizure of evidence. And the district attorney's office is sort of on the front line of defending that. So we have Assistant District Attorney Edward Lynch, who we call Ned because his nickname is Ned. So I don't call him Ned in the courtroom, so it's kind of fun to call him Ned here. But he's ADA Lynch to me, and you'll hear me refer to him as ADA Lynch because that's how I refer to him in the courtroom. And then we have Defense Attorney Rob Hoffman, who is Attorney Hoffman, who works for the Committee for Counsel for Public Services. So he would represent folks who are indigent, meaning that they cannot afford an attorney on their own, so the court appoints an attorney to represent them. He works for the Commonwealth of Massachusetts, but he's an excellent attorney, as well as a good person to deal with in terms of dispositions and things that we do on a regular basis, and so is Annette. So these two are daily combatants, if you will, where they are arguing in a very respectful way before the court, and I have to make the call with respect to whether or not one or the other has raised enough of a legal argument for me to either allow or deny the motion to suppress. If I allow a motion to suppress, that means that the evidence that was seized by the police cannot come in terms of its admissibility in furtherance of the Commonwealth's efforts. It doesn't mean the case is over, but sometimes it is the death knell to the Commonwealth if I say the evidence was illegally obtained, therefore cannot be admitted in the Commonwealth's case in chief. So this is a regular process that goes on, so we're just going to try to present the snippet of it. And I appreciate the opportunity of coming here. I'm very invested in doing this. This is my 6th year, John told me, of coming down here on a spring-like day. We usually come in late February or early March. And Ned and Rob have been great in terms of giving of their time, because we have to prepare for this. We have to produce the materials to do it. And Sergeant Jacek has agreed to step in, and he's a Harwich officer as well. So I'm pleased to be here both as a Harwich resident, as a judge here in Barnstable County, just to give you a little snippet of it, because I hope that maybe one of you, who's interested in being a lawyer? Let me see the hands. That's good. Maybe a couple of you might proceed, a career path that takes you in the law, or some, ancillary activity that would bring you into the court environment, never as a criminal defendant, of course, but just somebody who might be interested in getting involved in the many occupations that we have in the court system. So that's why I came down with Ned and Rob to present this little scenario to you today. So John Dixon, your teacher, has been great. Is this civics? What's the name of the class? Government?
United States Government.
Right. So how many constitutional law experts do we have in the class? Let me see.
Oh, you all are. Everyone raised their hand.
I didn't see it.
You.
All right. So you're going to ask me some tough questions after we get through presenting the scenario. So pretend right now I just came out. The court's in session. The case is going to be called by the clerk of the court, who's not here today. Probation's not here, but I have all these people who are giving the information. So the case is called, and I'm going to say, Commonwealth, do you want to present an evidentiary hearing on your motion to suppress?
We do, Judge.
ADA Lynch.
Sergeant Jacek, please.
So Sergeant Jacek will take the stand. He'd be sworn in by the clerk, and then the Commonwealth proceeds in asking the evidentiary questions that I need to hear, and then he'll be subject to cross-examination by Attorney Hoffman.
Sir,
ADA Lynch.
do you swear to tell the whole truth and nothing but the truth?
I certainly do.
Please be seated. Sir, could you state your full name and spell your last name for the record?
David Jacek, J-A-C-E-K,
Who are you employed by?
the Harwich Police Department,
In what capacity?
Detective Sergeant,
For how long?
for 33 years.
I want to draw your attention to the date of February 28th, 2013. Were you working that day?
Yes, I was.
Did you have an opportunity to be working at or about 12:30 in the morning?
Yes, I was.
What was your shift?
I was working the midnight 8 shift on patrol.
And your duty was to be on patrol?
Yes.
And at approximately 12:30 in the morning, were you out in the field?
Yes, I was.
Where were you located?
On Route 28 in West Harwich.
And at that point in time, did you make certain observations?
Yes, I saw a vehicle driving down the road. It had several occupants and it had a broken taillight.
So as a result of those observations, what did you do?
I applied the blue lights and I pulled the car over.
And were you with anybody else? Were you alone?
I was alone in my car.
And what kind of cruiser did you have? Marked or
The
unmarked?
SUV marked it.
So, and you initiated your lights and stopped the motor vehicle?
I did.
The motor vehicle stopped properly?
Yes.
And when you stopped the motor vehicle, what was the next thing that you did?
As I was walking up to the car, asked the operator for his license registration, I noticed that the other 4 occupants were, fidgeting around, looked like they possibly were putting things underneath the seat. Just a lot of activity, as opposed to just sitting still.
And when you say that they were putting things under the seat, describe what you saw.
People were ducking down and it looked like they were, the heads were coming in and out of view as I was walking up to the car.
Based on those observations, did you do something?
I asked for another unit to come for backup.
How'd you do that? Did you have the radio on your
With the
shoulder?
radio, yes.
Now, did you approach the motor vehicle at that time?
Yes.
What did you do?
Walked up to the driver's door and asked the operator for his license registration.
By the way, when you were making observations from outside the motor vehicle, did you make any observations concerning seat belts, things of that nature?
When I first walked up to the car, there were a few of the kids that did not have seat belts.
So did you receive the license and registration for the
I did.
operator? Did you ask for any identification or any understanding as to who the persons were in the motor vehicle?
At that point, no.
Now, at some point in time, did you go back to your cruiser?
I waited by the side window and then the second unit pulled up while I was still standing at the door.
And who was that?
That was Officer Tom Clark.
So when Officer Clark pulled up, you pulled up in the marked cruiser?
Yes.
But when he pulled up, what did you do?
I just gave him a quick rundown of what happened and told him we were going to be asking all the occupants to get out of the car because of the activity that I saw inside the car.
So what was the purpose of asking him to get out?
To see because it looked like they were possibly putting things underneath the seat. I just wanted to find out what was going on.
And so when you pulled him out, what did you do?
We gave each occupant a quick pat down to see if there was any weapons, and then give the car a search.
And what was the pat down? Describe what that is.
Just a quick pat down, just to make sure there aren't any weapons, for our safety.
And during that pat down, was anything recovered at all?
The operator of the motor vehicle had $400 in his pocket.
Now, after patting down the occupants, did you also search the motor vehicle for officer safety?
Yes.
Describe what you found, if anything.
There was a bottle of vodka in the back seat.
Now, in your interaction with the individuals that were outside the motor vehicle, did you have an understanding as to what their ages were?
They were all teenagers under 18.
And when you found the bottle of alcohol inside the motor vehicle, did you have a conversation with them about whose bottle it was?
Yes, and no one admitted ownership.
What was the next thing that happened?
Continued to check the car, And inside the trunk, there was, we found a couple of bags of marijuana. It was maybe a couple ounces.
And did you secure both the bottle and the marijuana that was found in the motor vehicle?
Yes.
Now, the driver, did you make any observations with him that caused you to do anything specifically with him?
Yes, the operator appeared to be slurring his words. There seemed to be an odor of alcoholic beverage on his breath, so we had asked him to take a field sobriety test.
And based on those tests, did you form an opinion as to whether or not he was under the influence?
Yeah, he was subsequently placed under arrest for operating under the influence of alcohol.
So there was an opinion that he was under the
That he
influence?
was under the influence of alcohol.
And so he was arrested, correct?
Yes.
And what about the other occupants of the motor vehicle?
Because of the location of where they were sitting and where the bottle of vodka was found, they were all charged with minors in possession of alcohol.
Now, at some point in time with regards to the operator, he was, as were all the individuals, brought back to the station?
Yes.
Now, specifically with regards to the operator, was he given an opportunity to do a breath test?
Yes. At the
And did
station, he was
Go ahead.
in the process of booking him for the operating under the influence of alcohol and the possession of the marijuana, but specifically the operating under the influence of alcohol. He has certain rights, and he was requested to take a breath test.
Now, as a result of all the observations that the police made on that particular day with regards to this motor vehicle stop and the incidents back at the station, were individuals charged?
Yes, all of them were charged with minors in possession of alcohol, and the operator was charged with the possession of the marijuana.
As well as OUI?
The OUI initially, but then we ended up having to drop the charge because of the reading of the breath test machine.
Why would that be?
Because he blew an 03 on the breath test machine, and that was under the 05, so under those circumstances, we have to drop the charge right there at the station.
So the charges at 140 were the possession with regards to the alcohol for all the individuals and the possession with intent for the marijuana for the driver, correct?
Correct.
No further questions.
All right, cross-examination, Attorney Hoffman.
Thank you. Good morning, Sergeant.
Good morning.
You were on Route 28 in West Harwich?
Correct.
Were you traveling on Route 28 or were you parked?
I was driving.
Driving on Route 28, you noticed a car with a broken taillight?
Correct.
Where was the car?
The car was, as I came around a corner, it was driving in front of me the same direction I was going.
Also on Route 28?
Correct.
So, you drove behind the car for a little bit?
Maybe a quarter mile.
Okay, for a quarter mile, you didn't notice anything out of the ordinary with the driving though, right?
No.
No swerving?
No.
No speeding?
No.
No braking and speeding up and braking and speeding up, none of that stuff, right?
None of that.
And when you turned on your lights, you turned on the blue lights? And the car pulled over right away, right?
Correct.
And it pulled over appropriately into a safe spot?
Just out of the road, yes.
And at the time that the car stopped, did you turn your spotlight on and shine it at the car?
The overhead alley lights to
The
light
bright
up.
white lights?
Yeah, they're bright. They light it. They shine to the front and help light and illuminate the front of the cruiser and hence the car that stopped.
And the idea is that the light can shine into off the mirror in the car too and sort of illuminate the inside of the car, right?
Correct.
And you mentioned that as you were walking up to the car, you saw some movement in the car, the passengers, right?
Yes.
Not the driver,
Not the driver.
but the passengers.
The passengers in the back seat.
And the movements that you saw, you described as them maybe ducking down, moving around,
Yes.
and the type of movement that might be considered consistent with either putting on or taking off a seatbelt, right?
Or putting something underneath the seat.
All right, and putting something underneath the seat, you did mention that you decided at that point that you were gonna take them out of the car to see what was going on with that under the seat stuff, right?
Correct.
And right at that point.
Yes.
And then you went up to the car and you asked for a license and registration, right?
Yes.
You didn't wait for your backup before you approached these individuals. And there were a number of 18-year-old or so kids in the car.
Correct.
Were they Harwich kids?
Most of them were.
So you knew who some of them were at least, right?
I personally didn't, but turned out they were all, I think all of them were from Harwich.
Okay. And they were cooperative. The driver was cooperative, right? Gave you your license, the license
yes.
and registration.
Yes, it was.
Nobody gave you a hard time. Nobody in the car gave you a hard time at all, did they?
No, they didn't.
And you testified that you had waited at that point for backup to arrive, and that's when you informed him that you were going to get everybody out, sir.
Correct.
Okay. You returned to your car and ran the the license and registration?
No, I never even got to that point. I just stayed at the car when the backup truck showed up, Officer Clark showed up. We just asked everybody to get out of the car and started patting everybody down and put them inside the car.
I'm gonna stop you there for a second. When you say you patted everybody down, you mean, look, you put your hands on the outside of their clothes like that, right?
Correct.
To make sure they don't have weapons.
Correct.
Nothing to harm you with. You mentioned that you found $400 on one of the individuals, right?
The driver.
Okay, so when you're patting this person down, what did you feel?
A lump in the pocket.
A lump in the pocket, but you didn't feel a gun?
No.
You didn't feel a knife?
No.
But you reached into the pocket and took that out, right?
Actually, I asked him to take it out.
Okay. You removed or had it removed from his pocket, right?
Yes.
And at that point, you'd already searched all of these people, and there's no weapons, right?
Correct.
And they're all cooperative,
Correct.
they're playing along, nobody's giving you a hard time?
Correct.
But yet you determined that you were gonna search the car?
Yes.
And you went into the car and you found a bottle of vodka in the back seat, right?
Correct.
You asked everybody whose bottle it was,
Yes.
and nobody said, that's my bottle of vodka, right?
Correct.
And you mentioned at that point, only after finding the bottle of vodka, that you realized that maybe this driver was intoxicated, right?
During the process of talking to him and getting his license or registration is when I detected the odor of alcohol, a little slurring of the speech, and figured somewhere before we were gonna figure out what we were gonna do, that I was gonna ask him to do a field sobriety test prior to us being completed.
All right, and you wrote a police report that night?
Yes, I did.
And you're trained to write police reports, make sure they're accurate, complete, all that?
Yes.
And put all the information in there that would be relevant to the charges that are about to arise, right? And you didn't put anything in your report about glassy eyes or smell of alcohol in the driver at any point, did you?
I thought he did.
Have a look. It's not in there.
It's not in there.
And at that point, you arrested the driver, after the field sobriety test, you arrested the driver, right?
Yes.
Did you ask any of the other individuals if they had a license, if they could drive?
I did not.
Did you offer anybody the opportunity to drive that car away from the scene?
I did.
And then you searched the trunk, right?
Yes.
And that's where you found the marijuana?
Yes.
That's all I have.
All right, anything on redirect?
That's it.
All right, you can step down, officer. All right, you want to give road attorney, Hoffman?
I do, Your Honor.
All right, good.
It seems pretty clear from the testimony of the sergeant that what we have here begins as a routine traffic stop, and my suggestion, Judge, is that it never becomes anything more than a routine traffic stop. This is a situation where the officer pulls over a car with teenagers in it for a broken taillight. There's no erratic driving, nothing like that. While the officer is alone at first, he calls for backup based on what he characterizes as some movement on the part of the passengers. The important thing, I think, to note here is, Judge, that the officer never said anything about a fear for his safety. And I think what underlines that, Judge, is he didn't wait for the backup to appear or to arrive on the scene before he went and approached the occupants of the vehicle. At that time, he was outnumbered, theoretically 5-1. Any fear for his safety could have been alleviated by waiting for the backup. I think it's very clear that this officer did not, in fact, fear for his safety. Nonetheless, when the backup arrives, or after seeing the movement, the officer makes a decision at that point that he's going to take these kids out of this car and he's going to search them. Before backup arrives, he has a conversation with them, gets license and registration. There is no indication that there is anything going on here at all. They're cooperative, they turn over the license and registration. When backup arrives, immediately these kids are taken out of the car and they're patted down. What I'd like to say, Judge, is the minute that the officers removed these kids from that car, under the circumstances that we have here, their rights were violated. Anything beyond that, any evidence discovered beyond that point should be suppressed. When they do the pat down, it's clear that in these circumstances, the law allows a pat down for officer safety. And again, I would suggest that there is no reason for a reasonable officer to fear for safety under these circumstances to allow such a frisk. But in any event, that type of pat frisk would be a pat frisk for weapons. The sergeant was very clear that in patting down the operator of that vehicle, he did not feel any weapons or anything threatening, but nonetheless, he had the operator remove an item from his pocket. I would suggest that that goes beyond the purposes of such a pat frisk, and that that should be suppressed, Judge. Once the pat frisk is done and there is no weaponry, there is no indication of any criminal activity, Judge, I would suggest that this is where this ends. A ticket for a broken taillight should be issued and these kids should be sent on their way. The officer did testify that at that point, with no further information, they searched the car. They searched the car, and at that point, they found a bottle of vodka. Once they find the bottle of vodka, Judge, I would suggest that it's a little bit unclear, but they start to think that maybe the driver's drunk, and it's clear from the report that at the time of the stop, there's no indication that these officers felt at that point in the report that this officer was intoxicated. I would suggest, Judge, that there was no reason to believe that this officer was intoxicated or for this to go any further. And I would also suggest that the search of the car was illegal. So even the vodka itself shouldn't be taken into account. These kids should have been sent on their way. The search of the trunk, Judge, I'm baffled by it. I don't know what kind of evidence the officers are looking for. It's very clear that they didn't offer anybody the opportunity to drive away. There was no testimony that these individuals being charged with possession of alcohol were necessarily going to be arrested at that point. I think that comes up after they go into the trunk. Now, my question is very simple. Why go into the trunk? What evidence are they looking for? They've got a bottle of vodka. The only crime we've got here besides this so-called OUI situation is possession of alcohol. There is no reason to believe that there would be any other alcohol in this car. And frankly, Judge, at that point, that's the only criminal activity that the officers have any reason to believe is going on. Based on the fact that anything beyond the stop was illegal. This never went beyond a routine traffic stop, Judge. These kids never should have been brought out of the car. Everything should be suppressed. But in the event that the pat frisk is found to be okay, everything beyond that should be suppressed anyway. As the money was removed, it wasn't a weapon. There was no reason to believe it was. And the rest of the evidence comes from an illegal search of the car.
All right, thank you, Attorney Hoffman. ADA Lynch?
On behalf of the Commonwealth, Judge, I would suggest that the motion by defense should be denied. We would suggest that the evidence of the bottle that was found in the car, the $400 cash, the marijuana that was found in the trunk, as well as any statements that the defendants made, should certainly come in as evidence against these individuals when the case proceeds to trial. We would suggest and we would agree that perhaps, although this matter started as a routine traffic stop, as it developed, there were other issues that presented itself to the police officers that certainly gave them authorization each and every step along the way to do the things that they did and to uncover the evidence that they uncovered. Specifically, again, we would suggest that the officer, Sergeant Jacek, was within his right to stop the motor vehicle after observing the motor vehicle violation. He then approached the motor vehicle and during his approach made observations of movements inside the motor vehicle, individuals within the motor vehicle moving down toward the seat area. In a situation like that, it's certainly reasonable for this sergeant, as well as any other sergeant in his shoes, to believe that he's concerned for his safety. He has every right, once asking for license or registration, to certainly, when he has the other officer present, pull these individuals out and do a pat frisk for his safety and the safety of the other officer. In doing so, he did uncover the $400. It's clear the case law would suggest that we also have a right in situations like that to extend that pass through of a person into the motor vehicle. It doesn't make sense that an officer who's concerned for his safety would be limited and be required to put that person who he's concerned about back into the motor vehicle where he might have access to the thing that he might have hidden under the seat. So certainly that pat frisk could certainly go back into the motor vehicle. Once the officers are rightfully within the motor vehicle, they make observations of the bottle of alcohol. At that point in time, they have information that the individuals are under 21 years of age. They see the bottle of alcohol there. There's certainly probable cause at that point in time to establish that the individuals within the motor vehicle are in possession of a bottle of alcohol. They are in violation of the law in being underage. Once probable cause is established at that stage, based on that plain view observation of that motor vehicle in a place where the officers have a right to be, the motor vehicle could be searched and whole. So that means the area of the compartment where the passengers are, including the front and back seat, as well as the trunk, can be opened up and could be examined for evidence in that particular situation. And in doing so, if they come across marijuana, certainly that should be admissible at any future proceeding. So the government would suggest, Judge, at this point in time, that every step along the way, as this process developed from a routine traffic stop up until the point in time when that marijuana was found, that the officers acted lawfully and there was no violation of any constitutional right, the motion should be denied.
What am I gonna do? This is a classic motor vehicle stop. The police are subjected to, and they have the right to be there. So we have to balance, right? This is the High Wire Act. You're too young to remember the Walenda High Wire Act. I won't even be able to go there. John, you're old enough to remember that. Flying Walendas. But we're on the high wire right now, and we're trying to decide whether or not the Constitution has been violated. Now, the Constitution was written back in the 1700s. So the Constitution, I know Mr. Dixon's told you this, is a living document, and it's been brought forward to modern day science, where even now we're dealing with technology issues we didn't even know existed when I went to law school, because I'm old. But back in the 1700s, they didn't even know that police officers were going to have mobile data terminals in their car, the ability to call for backup on a radio, and all of these things that we now have. So what we do is we have the basic bedrock constitutional principle, Fourth Amendment. What's the Fourth Amendment of the United States Constitution? Who knows? But,
Equal protection from unlawful seizures and searches?
yeah, everybody has the right under the Constitution. So this is what we call a right. We have a right guaranteed by the Constitution not to be subjected to an unlawful, very good, illegal search and seizure. So the police have their job to do. They have responsibilities to keep us all safe. They have responsibilities to make sure that no one is engaging in criminal activity within their jurisdiction. That's their sworn duty. They're out there to protect us. And we have rights too that we want to safeguard and protect, but it's that High Wire Act of where do we have rights and where do we have responsibilities to act reasonably as citizens. So driving along Route 28 at 12:30 in the morning is not a crime, right? So they were both very convincing, weren't they? So what happens at these evidentiary hearings is that I'm listening, to the police testify under oath, and the police never tell anything but the truth. They don't. They're under a legal obligation when they sign a police report. They have to certify under the pains and penalties of perjury that what they wrote in the report is true. Now, sometimes the defense can shoot holes in it, and the Commonwealth has to sort of go along with that. But at the same time, I don't have a video of what happened that night on that particular occasion. I have to glean from the facts, and I take notes, and I listen carefully to the facts, because this is all about what we call proportionality. I have to parcel out the sequence of events, because that's going to dictate how I'm going to decide this motion to suppress in light of the Fourth Amendment protection against illegal searches and seizures. So how do I get there? Well, I start off with that basic premise, and then we transfix it into modern day, the year 2013, because we have a motor vehicle stop, and we have case law. So we have the Supreme Court of the United States, right? Then we have the state Supreme Court, which we call our state Supreme Judicial Court. We have our state appeals court, and then I'm down here. I'm just a lowly trial judge. But I get my direction from case law. I know Mr. Dixon taught you that. It's called stare decisis. It's the only time we ever use that legal term. Tell them about stare decisis and precedent.
Oh, they read about stare decisis.
Oh, sure. So what's stare decisis? Come on, remember this. It's the only time we really use law. It means to stand on past decision. So we try to have some predictability in the law so that we as citizens have knowledge. We're given due process, upfront knowledge of what's legal and what's not illegal. That's why we have law books, and that's why we have information, and that's why we have school, and that's why we have government classes, and we teach people. This is the Constitution, but you have certain rights, but you also have responsibilities to act appropriately as young adults. So, I'm getting wordy, but I just want you to understand where we're coming from. So, we have cases that have decided along the way, this is appropriate, this isn't appropriate. But there's no bright line standard. There's no bright line rule. There's no ability for me just to take this information and sort of feed it into a computer and then spit out what the answer is. Because there's a human element to this. So I have to decide, based upon case law, whether or not these specific tailor-made facts and circumstances qualify for an allowance of a motion to suppress that's filed by the defense that's vigorously defended by the Commonwealth. So how am I going to do it? Well, There's a couple of cases that I'm gonna bring to your attention. They didn't argue in the case law, but trust me, these two know the case law, and they can spit it out as fast as we talk. They can get it out there. Even Ned Lynch doesn't, he sleeps with this book. This is the law book on suppression matters, right? And we get this book, it's updated once a year, and we get all the cases from our state Supreme Judicial Court. Attorney Hoffman has a copy of it too. But he carries this with him everywhere, and I have to memorize this thing and stay ahead of him, so I know what the heck he's talking about. So I did my homework too. So there's a case, and it's called Commonwealth versus Gonzalez, and it came down in the year 2000, and it says, you know what? We're not going to allow the police to to force people to exit their vehicle unless there is some suspicion of criminal activity, a so-called exit order. In other words, you don't just drive up, everybody out of the car. They can start shining their flashlights and they're looking for stuff, and they start looking under the seats and looking around. So this case, Commonwealth versus Gonzalez, put a little bit of a chilling effect on the police ability just to take people right out of the car. Now, that was later modified by this other case called Bostock in 2008, I think. And Bostock says, well, Gonzalez was a good idea, but we have to give the police a little bit more of assistance here. And that is that if the police officers fear for their safety, and they have some reasonable, articulable suspicion that suggests that they fear for their safety, in those circumstances, for sure, because officer safety is paramount, right? It is. And we don't want the officers to be subjected by some surprise attack by someone who might get crazy and shoot them or pull out any other kind of a weapon. So we're going to allow them, if they can articulate specific facts that says that there's their fear for their safety, to require the occupants to exit the vehicle. So that's what Bostock says. Now, so in light of that, I'm trying to look at the proportionality of the intrusion, because we have a car. Now, ideally, this is ideally how it should work, and I think the people who wrote the Constitution probably have this in mind. No one should be subjected to an illegal search and seizure unless they get a warrant by a judge. But guess what? At 12:30 at night, I'm asleep, right? They're not going to be able to come to me and say, oh, the officer's not going to say, Sergeant Jacek is not going to be able to say, excuse me, would you people just stay right here? I'll be back in a few hours. I'm going to go get the judge that's on call. All right, now don't move, and don't touch anything that's in the car. I'll be back, right? And then leave and go get a judge and present all this information, get him out of bed, we have a full hearing, like we just had, and then the judge says, well, okay, Sergeant, you guys can now search the trunk, or you can search the back seat, or you can shine your light. That doesn't work, right? Because we have this thing called exigent circumstances. What's exigent circumstances? You learn this. Emergency, right? It's an emergency. We don't have time to get a warrant. So this is a warrantless search situation, which engenders all of this case law that I'm trying to tell you about. So in the warrantless search situation, it's an after the fact. It's, in other words, it's already happened. The search has happened. So now what's being tested by virtue of the evidence is whether or not I should allow it or deny it. Now I gave you all the law. Now I need help. I need some help. What am I going to do? Yes?
I just have a few questions.
Sure.
Did you fear your life with these kids? Like, did you fear them before you approached the vehicle?
Well, this is not cross-examination.
I need to ask, like, did you? Is that why you called for backup?
Just for the numbers.
For the number of
I'm
kids?
1 and they're 5.
And who knows what people have in the car? He doesn't know. He's not clairvoyant. He can't see through the seats. He can't see what's going on. He doesn't know what might have been stuffed under the seat. We call it in the law furtive gestures, that the occupants made gestures. Now, they could be consistent. Notice how Attorney Hoffman said, couldn't it be consistent with them taking off their seatbelt? Yeah, that was a good one.
That or the light, because you said you shine your spotlight.
But they call them takedown lights. They have lights on the cars that can shoot in really high-powered and high-intensity lights. Plus, they all have flashlights. They love their flashlights. They have big mag lights, right?
60 candle, a million candle power.
Yeah, he even knows how many candle power, so they can light up the car. And they should have that, because this is their safety they're talking about. They're trying to see what's in the car. So go ahead.
I don't know, I just felt like the search was, I know this is like not legally the appropriate word, but stupid. Like, I feel like it was unlawful, and I don't know, I feel like because they're 18, they're no longer kids, they actually have, you know, like rights. You know what I mean? I mean, kids have rights obviously, but I mean, you're an 18, you're an adult. you have the right, yeah, you don't have the right for the liquor and the marijuana, I get
Right.
that, but
That's
the
what
whole
this is
search
about.
itself was the,
Let me make one point about safety, and that is that an officer in the course of his career might do 1,000 traffic stops. All it takes is one of those to be someone who's a loose cannon, who's armed, and you're not going to make it to retirement, and you're not going to go home to your wife and kids. So, to a certain extent, you have to, as an officer, approach every traffic stop like it might be that 1 out of 1,000. Because you want to make it home to your wife and kids and get to retire someday. So, you know, was it likely in this scenario that the kids were armed? No, it wasn't likely.
yeah, but he patted them down, which I think, again, was ridiculous that there was even that, but I get the whole safety situation that you said could be that one time. But you searched, you patted, nothing seemed wrong, everything seemed fine, they were all cooperative, no one was being rude, no one was, and in the report, didn't say anything about anyone acting drunk or
That's right,
seeming
no,
drunk.
that's definitely right, these are all good points for me to consider, yep.
So
But,
I just feel like.
again, proportionality, let's start, it's almost like watching the movie, it's already happened, right? We're gonna watch the movie, we're gonna try to assimilate what happened on that particular occasion. So, the police have an absolute right under this thing called the community caretaking function to let us all know when our tail light's not working properly. They have the right to pull you over for that, or any traffic violation, because that's what our laws say. Okay, the legislature passes laws, we call them statutes, right? So the legislature said, you know what, officers, if you see a broken tail light, pull the occupant of the vehicle over and let him know or her know that the tail light's out so they can get it repaired, that's all. But in the course of that, if the police, not just based on a hunch or just a fishing expedition, you call it, I'm using all these words because that's what the case law talks about. You can't just take kids out of the car and hassle them. That's not what this is about. So I'm here to make sure that that doesn't happen in terms of my rulings, and the police get the idea of that because they go to trainings and they understand, you know, what the parameters of what they can do and cannot do. So this is not like a game, it's just more or less balancing. It's a high wire, like I said. It's, you have rights, responsibilities. They know you have rights, but they have responsibilities. They have responsibilities to themselves for officer safety. They have responsibilities to the public to uphold their duties because they're sworn in as officers of the law. They have the power of arrest. We give them that. We clothe them with it. We give them the badge. So that's what this is about. All good points. You had a question. Someone had their hand up over here. Yes.
Question for you. Is it for an officer protocol for a broken tail light to inform them of the broken tail light before you ask for license and registration? Or is it still you ask for license?
Usually you get the license registration.
You said you
Okay,
didn't-
okay, Mr. Smith, this is why I'm stopping you. You got a broken tail light or you're crossed over the mark.
How do you inform them of the broken tail light?
Usually after I get the license registration.
Because you said you didn't run it through the system. I just didn't know if you informed them of the actual intent of pulling them over.
I don't know if you can hear his question, but he's talking about the initial part of the encounter. Is it police protocol to ask for license and registration? Yes. We have this thing called, they have the right to ask you your name. This comes with your license. If you're licensed to operate a motor vehicle, it's a privilege, right? You all know this by now, going to driving school and getting your license. It's a privilege. So as part of getting a license, you automatically sign up for the fact that the police can ask you for your license and registration to identify you. Why? Because we have an electronic warrant system, so if somebody is a fugitive from justice, they defaulted in their court case, they have the ability right in the car to check the license plate, they can check the occupant by name, and they can decide whether or not a person has a warrant. Have you ever stopped anybody that has an outstanding warrant, Sergeant? Yeah, that's a ticket right to the jail, because it's already been determined by a judge that a warrant should issue, so he has the right to take that person right into custody. You go right past go. You ever play Monopoly? Yeah, it gets the $200 on that one. So, yes, we as citizens have to give our name and address. We can't give a false name.
No, I understand that. I just didn't know if he had informed them of the broken tail
Well,
light.
first, he wants to make sure he doesn't have anybody that's driving without a license. That's a criminal offense, or driving with a warrant, or is outstanding, is wanted by the court system. So he has the right to ask for that. Okay.
Usually it's license registration, thank you, okay, this is why it stopped.
Yes.
How do you decide?
I need help on deciding this in the class. It ends in about 12 minutes. I need help. Go ahead.
When is it okay to move from searching just the car to the truck?
Aha. This is really huge. ADA Lynch has a loser on that one, and he knows it. You can't talk back to me like this. This is good. You cannot talk back to me like this. That's an excellent point, okay? They can't get to the trunk unless they have the right to seize the vehicle in its entirety. We call that an inventory search. So they kind of pass go on that one too. Because if they have the right to get the car and take the car, they tow the car to the police tow lot, right? They have rules and regulations and policies and procedures on, I'll get you, on towing the vehicle. Then once they have it in that pristine environment of the tow lot, then they go crazy and start getting the dog to sniff. We have a whole bunch of cases on drug sniffing dogs that are trained. It's really pretty neat stuff. And people drive around with these things called hides, and they come out with a huge amount of drugs that are trying to be infiltrated into our neighborhoods, and that's a whole different thing. But that was a very good, astute observation. Yes?
What if it's like a hatchback or like an SUV, you know,
Yeah.
some with windows?
Yeah.
It's still a trunk.
Oh, sure.
So
And-
what's the limitation?
Well, Ned mentioned, or ADA Lynch mentioned, the plain view doctrine. The police have the right to view items, and if you're not smart enough to put your incriminating evidence in a place where it can't be viewed in plain view, then too bad. The Constitution says the police, if they see illegal marijuana on the seat, or they see glassine bags full of heroin that they suspect is heroin, they don't have to get a warrant for that. They can seize it. That's called the plain view doctrine. So if you decide to have a hatchback, and some of them have tinted windows and all that, if it has one of those covers over, that's like the trunk. But if the hatchback's open and you have, 2 kilos of heroin in your back of your hatchback, you're in trouble. If they can see it with a flashlight, or they can see it during daylight, like right now. They can use a flashlight. A flashlight does not connote an illegal search. They have the right to use a flashlight or any other aid to view what's in plain view. It's called a plain view. Okay, back to this. What am I going to do? Come on, help me now. You're all students of constitutional law. I have to make a call here. Yeah.
Well, so we need probable cause to search the trunk?
Well, not probable cause. He used the words probable cause. We call it reasonable, articulable suspicion. So it's not based on a hunch. It's not based on an objective standard. By the way, if the officers came up and saw the butt end of a gun or bullets on the console, bingo, now we're talking a whole different realm. We're talking officer safety big time. He can get them right out of the car in that scenario. That wasn't the case. I'm changing the facts. Because now we're talking a pure Bostock case. That's the case about if the police officer's safety is in jeopardy and they can articulate it right at that point in time, bam, you're out of the car. And you're under arrest. But in this one, the facts are leaning towards the defense because he doesn't have a Bostock stop. He has a routine traffic stop that they tried to transform into an officer safety situation 5-on-1. That's what they have. Now I just gave it away. All right. So, who else had it? Someone else had it? Yes.
When you did the field sobriety test, after you performed it, did they seem okay? Like, did they pass it?
Yeah, they didn't, that's why he was.
They didn't pass it,
They didn't pass it, no.
So how come when they got to the station, they were within their legal realm for driving?
Some people just don't hold their rules very well.
Also, people are very nervous. If you've ever been stopped by a police officer, you get very nervous. And, the police are into, this is part of their regular environment. But, the blue light goes on, you say, and then, out of the car, and you get nervous, and they start asking you a million questions, which they have the right to do, and people get nervous, and we take that into consideration at the time we're listening to it. And then he blew a .03, so in this case, the breathalyzer was actually the savior. As you heard, they dropped the charges. They didn't go forward on that charge because the chemical analysis test didn't make it. Yeah.
As the driver of the car, can you just give your license registration and plead the fifth?
Plead the fifth?
Yeah.
Oh, sure. As you heard, ADA Lynch wants all the statements, all the incriminating statements that are right there. I don't think it's a wise move when they say, "What's your name?" I take the fifth. I mean, they have the right to ask that question, but surely, now you just brought up another whole thing. There's not a lot of statements that were made in this case, but clearly we have huge motions to suppress on this constitutional guarantee. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be how am I doing, Sergeant? Good. So those are what the officers do. They read the rights to the individual. Now, if you waive your Miranda rights, this is the Miranda versus Arizona case, if you waive your Miranda rights, anything you say, he loves it. He sucks it up. He wants it because he wants to put it in front of the jury and say, this is what he said, consciousness of guilt. I'd like to have a nickel for every time ADA Lynch has said, Your Honor, consciousness of guilt, consciousness of guilt. He loves that, doesn't he? I'm sorry. This is fun because I can't do this. Yes.
I was trying to get at was the fact that your basis for searching the car turned out to be wrong, so wouldn't everything after that search be
Yeah, that's what he's trying to say. He's saying, you know what, officer, you did a great job. Broken taillight, you informed the person, of it. You suspected him of OUI. You did a great job. You let him go. I'm sorry they had some marijuana and vodka in the car, which, by the way, if it's legal or not, we're not going to get into how much and how much is per person. I'm not going to get into that. But he's saying, great, everything up to that point is fine. I have no problem with the stop. I have a problem with now them facing charges, everybody under this joint enterprise. He loves joint enterprise. Do you like joint enterprise? Tell him what joint enterprise is. Hurry up.
It's well, you can be responsible for a crime as a principal, but if you're also present and you share the intent that the crime be committed and you do something in furtherance of it in any way, like acting like a lookout or doing something like that, you can be charged just as the principal for the crime. So
They love it. One person does something, you happen to be with them that day, and they say, you're an aider and abettor. They love it. Get everybody, charge them all. I'm sorry, I get all emotional. Well, yes.
Did we fail the breathalyzer test?
Yeah.
And none of them claimed the bottle of vodka. How do
Yeah.
you know that it was actually theirs?
We don't know, but that's the subject of a trial. So the jury would have to decide whether or not the driver was impaired. And there's a whole jury instruction that we have on operating under the influence of intoxicating liquor. And the officer also has a responsibility to me and the rest of us, because if the driver is impaired and he lets the driver go, he or she, and they drive down by Cream and Cone and wipe someone out on the side of the highway because they're impaired, the public's going to scream bloody murder and say, you let that drunk driver go and he killed my son or daughter or me? They have an obligation, and there's a civil liability to this that came out of this, and it happened in the town of Ware, Massachusetts, which gave rise to a whole set of different laws. But the police have an obligation to take drunk drivers or persons off the road that can hurt other people. So if they don't act, they subject themselves to civil liability as well as the public outcry that would come as a result of that. All right.
Ready for your roll?
Ready. I would have to allow this motion to suppress based on Commonwealth versus Bostock. So maybe Mr. Dixon will give you a copy of the case to read it. I'll be happy to give it to him. He can make the copies and give it to you. I would suggest you read it because this case has just about everything you'd want to know about a motor vehicle stop under this type of situation. So I'll give it to him and he can make a copy of it and give it to you. All right? Any other questions? Comments? I want to thank the officer, the sergeant, who came in and testified on the last minute. He didn't have any idea what the facts were. We just told him. He did a good
And
job.
it wasn't my report, it was his.
You have a question?
Who won?
Yeah, go ahead.
Who won? Defense won the
Defense.
motion to suppress. So the evidence beyond the traffic stop was suppressed, or would be in this
Would be.
hypothetical.
I'd have to write a decision. So the way it works is I would listen to them. They both had a chance to argue. We did it real fast, so that time to check. And then I would take it under advisement. I would write it up. I file a decision. And then the Commonwealth can take me up on appeal. They have the right to appeal the judge's decision, right? Yeah. So we could go to the appeals court, and then another level of the court could take a look at this, the appeals court, and they could say, Judge Rufo was right or was wrong.
Jack, let me just summarize based on the cases we have looked at. The Terry versus Ohio case, which we looked at, that's the one that suggests that the probable cause standard does not apply when officer safety is involved. And in that case, reasonable suspicion of a weapon being present is all an officer needs to search. When, in other words, in another circumstance, it would need probable cause. So in this case, the officer believed that he was justified based on the Terry standard to search the vehicle and to search the passengers. But in review, what the judge said is, well, given the specific facts of this case, it seemed more like you were looking for a way to get in the vehicle than you were really concerned that you thought realistically that they would have had a weapon. And then the standard, once, if you are able to search the car, then of course, the evidence, the alcohol evidence would have been good. And what our case law, we said, well, once you have probable cause on the vehicle, that would extend to the trunk if there was probable cause, and the presence of alcohol and nothing but minors would have amounted to probable cause. But because the judge, based on the specific testimony, did not believe or did not find that the officer sincerely feared for his safety, therefore the Terry standard wouldn't apply, and therefore he would have needed more cause to search.
Yeah, this is a routine traffic